Great, thank you, Annie. Sorry about that, everyone. I was looking at the chat and got distracted when I should have been paying attention to the slides. So I'm going to take you through the Human Rights Act. So what is the kind of law that we currently have now, and how does it work? And that's really important because there's quite a lot of sort of misunderstanding or misperception or misinformation about the law that as it stands now and the case for change. So it's quite important to kind of skill ourselves up in knowing exactly how it works right now to be able to kind of counter back and have those conversations about why maybe some of the proposals may or may not be useful. So we're kind of going to go sort of back to basics in terms of what is the Human Rights Act and how does it actually work. So this thing that we're reviewing right now and potentially could be changed. And then Annie's going to talk to you a bit about some of the rights that are in the Human Rights Act, which might be impacted by the proposed laws that are also being discussed when kind of Parliament returns. So, the Human Rights Act, the importance of it. Human rights laws in general, their purpose is to set minimum legal standards. So we sometimes talk about them as sort of being the rule book for how states treat people. So they are about our relationship with those kind of institutions, people that have public power or government kind of power. And the way our Human Rights Act works is that it makes that idea of like who is the state really tangible and really meaningful, because it talks about the kinds of sort of public organisations and bodies that we interact with on a day-to-day basis. So our Human Rights Act, which is the law that kind of covers the whole of the UK, it brings rights from the European Convention, and I'll talk to you a bit about that in a moment, into UK law. But what's really important is the Human Rights Act is what creates all of the duties about how those rights should be upheld in the UK. So very often you'll hear people say, well, it kind of tinkering with the Human Rights Act isn't going to make a huge amount of difference because the government has committed to staying within the European Convention, for example. And that's great, and that's a great commitment to stay within the European Convention, but it's actually the Human Rights Act that lays down all of the legal duties in our domestic UK law about how we can access those rights. So it's kind of important to know that they're two different laws that are very related, but they serve slightly different purposes. So what the Human Rights Act does is it kind of creates this set of legal duties on public authorities, which is the language used in the Human Rights Act, and that's things like sort of NHS services, for example, is a really clear public authority that many of us will have interacted with, particularly over the last 18 months or so. And it also applies to anyone delivering a public function. So that might be a private company running a prison, for example. So it's kind of quite a broad reach. And it's also really important to say that in terms of human rights standards, they should be protected all of the time. And sometimes there's a bit of a perception that in sort of times of an emergency, for example, like the kind of public health emergency that we've been through, that human rights are a kind of optional extra, and that we don't need them in those times. But actually, if we look at the history of human rights as legal standards, as we understand them now, they were really born out of dire emergency situation in terms of the Second World War. So kind of human rights were born out of those sorts of really kind of desperate times and the setting those standards for trying to prevent them from happening again. So they should be protected at all times, but they are also especially important at times of emergency or difficulty. So talking about the difficult situations that we might find ourselves in now shouldn't really be a reason for trying to unravel those protections. I said I'd talk a little bit about the European Convention on Human Rights and where it comes from. So we often teach a university course at a university in London, and this is about the first 4 weeks of our university course rolled up into one slide in a couple of minutes. But it's just to sort of explain that relationship between different human rights laws and kind of where they come from and how they relate to each other. So I talked about sort of human rights being born after, as legal standards being born after the kind of Second World War, really. That's where community came together. established the United Nations, and the first thing that the United Nations did was to create the Universal Declaration on Human Rights, which was this kind of declaration, this standard setting of a set of basic rights that every person should have just because they're a human being. So not kind of because they're a good human being or a bad human being, or because they fit a particular mold or they behave in a certain way, but just all people should have these rights. So kind of that Universal Declaration really set that down and kind of set us on the path of putting those rights into laws. And at the international level, there's quite a lot of human rights laws, and through the UN system there are laws that cover particular issues or groups. So there's a convention, which is an international law, which is for children. There's one for disabled people. So there's a whole range of kind of different groups, and that kind of happens at the UN level. Now, the way the UK works is that our governments, current, past, future, can agree to these international laws on human rights on behalf of the UK. But in order to enforce them, for us as people to enforce them, we have to have a law passed in our UK Parliament that kind of takes those laws and brings them down into our domestic law. And we haven't done a lot of that with international laws that kind of are created at the United Nations level, but we have done it with the European Convention on Human Rights, because that's what the Human Rights Act does. So at about the same time that the UN was creating international human rights law, we also had the European Convention on Human Rights being created by the Council of Europe. You'll see there in big red letters, it's not the EU, it's an entirely separate institutional framework, different set of countries. And the Council of Europe is the whole idea of it is to try and bring peace and democracy and respect for law and human rights across the whole of the European continent. And what the European Convention did was create a court. So individuals in any of the countries of the Council of Europe could go to the European Court if they thought that their rights were at risk. And that's really important to kind of have that mechanism. But there are 47 member states in the Council of Europe, and every single country, every single person in every single one of those countries has the potential to ask the court to look at their case or their issue. Doesn't mean that it will be a legal case, but they can ask. So it gets very busy. And it can take quite a long time. So the idea is that the Human Rights Act takes rights from that European Convention and pulls them into UK law and sets out all of the legal duties for how we can access our rights here at home. So you'll often hear the rights in the Human Rights Act called the Convention rights, and that's because they were first written in the European Convention and now they're part of our law here in the UK. So that's about the first 4 weeks of undergraduate human rights law in a couple of minutes. It's also important to flag devolution as well, and we can see from the chat that we have people from some of the devolved nations with us as well, which is great. The Human Rights Act is a UK-wide piece of law, so the kind of duties I'm going to talk about in a moment, they apply to public officials, public bodies in the kind of 4 nations, Scotland, Wales, England, or Northern Ireland, all have the same legal duties under the Human Rights Act, and kind of all people in each of those devolved nations have the same human rights. The devolution arrangements mean that parliaments or assemblies in the devolved nations can't pass laws that would be incompatible with human rights, and that's because they're not kind of what's called sovereign parliaments or sovereign assemblies. They have their power given to them by the Westminster Parliament. So you sometimes hear talk about judges having kind of too much power in human rights law. And we'll kind of look at it in a moment, because when we think about UK-wide and the Westminster Parliament and the courts in that situation, they don't have a huge amount of power, but there is a little bit more power for some of the courts in the devolved nations if a parliament or assembly there has passed a law that might be incompatible with human rights. So there is a kind of slightly different scenario and situation there. And it is also important to remember that the conversations about human rights in general and the Human Rights Act particularly are quite different in the different evolved nations. So they're not always quite exactly what the discussion in the Westminster Parliament is. So the Human Rights Act and democracy, and kind of how we can kind of think about breaking that down and kind of the roles of each of them, to understand a bit of the criticism that's often levelled at human rights and the Human Rights Act, and why things need to change, so that we can kind of come from a basis of knowing sort of how the system works. So within our system, government proposes laws, and so we have the proposed laws that Ali's already mentioned, that she's going to talk to a little bit about them, the ones that kind of we're a bit worried might actually lead to kind of reduced protection of our human rights. So government can propose those laws, and when they do so under the Human Rights Act, they make something called the Section 19 statement, which is their assessment of whether they think it is kind of respectful of human rights or complies with human rights. That's not legally binding at all. It is useful in campaigning, because often they won't just do a statement, but they'll do a kind of note of that and outline how they think human rights are or aren't affected by the proposed law that they're putting forward. So when you're campaigning and thinking about sort of how you might campaign around some of those proposed laws, it gives you an insight into the arguments that the government might make. And then in Parliament can kind of make laws, they can debate laws, they can change laws. So Parliament is sovereign. So Parliament isn't bound by the Human Rights Act, and they can make or unmake any law that they like. That's the Westminster Parliament. And then we have the courts, and the role of the courts is to review whether laws that have been passed or the actions of public bodies, whether that's local or national, are complying with the Human Rights Act. So they can make a kind of an assessment of whether human rights are or aren't being upheld by either actions or decisions or particular laws. What the Human Rights Act doesn't do is allow judges to overturn or strike out or kind of get rid of laws that are made by the UK or kind of Westminster Parliament. So if you like to watch American courtroom dramas and something goes to the Supreme Court there and out kind of goes a particular law, that's not how it works. Here judges don't have that power, and that's kind of sometimes contrary to maybe sort of some of the discussion that you often hear about the Human Rights Act. So what judges can do in some of the higher courts, so not every court or every judge, but it has to be the higher ones, they can make something called a declaration of incompatibility. And that's a statement that says this law doesn't uphold human rights, or we think there's a human rights issue with this law or this decision, with this law, and then that law stays in place until Parliament approves a change if it decides to change it. So it's still up to Parliament to change the law, even if there is a declaration of incompatibility. So that's a little bit about a kind of a sort of overview, a real overview whistle-stop tour around kind of the different sort of institutions in our democracy and how the Human Rights Act works with them. So the three ways that our Human Rights Act works that it's kind of helpful to think about is that it firstly puts a legal duty on public authorities to respect and protect human rights across their actions, decisions, policies, services, and I'll talk a little bit about that in a moment. And it also applies to those performing public functions. So it isn't just kind of your traditional sort of policeman or police authority. It might also be a business that is running a service for the local authority, providing a particular type of care, for example. So it can be quite wide ranging. And it's important to kind of say that's a legal duty, not a moral duty, which I think there's sometimes a bit of confusion about. The second way it works is that other laws should be applied in a way that respects our human rights so far as possible. So we'll look at that in a moment, because that's also going to be really important when we're thinking about campaigning around proposed laws or bills that might actually impact our human rights, and kind of how we might argue for a different way forward. And if these two things don't happen, then we can now bring legal cases in the UK courts if we need to. So we don't have to go all the way to the European Court of Human Rights. We can still go there, but that's the last place you would go to in a legal case usually, rather than the first place. Now you can bring a case here at home. So the legal duty, this is kind of just a bit of the actual wording in case it's helpful in Section 6 of the Human Rights Act. So it's unlawful for a public authority to act in a way which is incompatible with a convention right. So essentially means the kind of public officials, the people carrying out those public functions, need to uphold human rights in what they're doing. And it is a real kind of wide range, as I say, a really wide ranging duty. It's not very well understood. So it's important to bear that in mind, that sometimes when you might be saying that might be the first time somebody's hearing that. And it's also really important to say that public authorities include courts and tribunals and regulators. And so again, when we're thinking about, in the longer term, kind of, do we want to raise human rights issues in other fora, courts need to also be mindful of upholding human rights when they're making decisions as well. What does the legal duty mean? It's kind of useful to break it down. We talk about it as respect, protect, fulfill, which is used quite a lot in the international language, and the European Court, when it talks about this, uses these phrases as well. So it's really about public bodies and their officials either kind of respecting your rights, so kind of not restricting them, trying not to breach them. It's about protecting them, so it's stepping in and doing something positive to protect people from harm. Often that's what safeguarding is about. You'll probably hear that a lot more frequently than you hear the phrase the positive obligation to protect human rights, but they're kind of essentially born from the same sort of kind of set of laws. And then fulfill people's human rights. So essentially that's about kind of processes and looking at what's happened when things have gone wrong and trying to stop that from happening again. So that's a little bit about kind of what public authorities should be doing. The foundation law element, I think is really important to talk about, because again, it's often a misunderstanding of how human rights work with other laws. Section 3 of the Human Rights Act is actually all about sort of how we should be interpreting and applying other laws in a way that makes them compatible with human rights so far as possible. If they say something that's a breach of human rights, then you can't interpret them in that way, of course not. But very often there will be a way of understanding a piece of law. So one of the classic examples that we use is around housing legislation, which kind of old housing law used to talk about people who lived in kind of essentially talking about married couples or heterosexual couples, and so it prevented people in same-sex relationships from inheriting tenancies when a partner died. And the courts were able to say, but you can interpret kind of spouse to be spouse-like, because at that time people in same-sex relationships couldn't get married or have civil partnerships. So the court said, well, you can interpret spouse to kind of also include spouse-like relationships. So that's really important. And I think it's important to kind of, we can use that thinking about campaigning in terms of, we should be trying to get new laws right at the start. So we should be trying to make them compatible with human rights right from the start, and kind of campaigning for that, kind of right when they're in Parliament, and encouraging our parliamentarians to make them compatible. But it does also mean that if proposed laws do become law eventually, they will still need to be applied compatibly with human rights. So even kind of if laws do get passed, that's not kind of necessarily the end of the story, and kind of we can think about other additional ways we could use human rights in some of the campaigning. And then court cases. So it is now possible to bring human rights cases in the UK court. So as I've previously said, we don't need to start our cases at the European Court of Human Rights anymore. It can be quite a remote route. It's really important to have that and to have the availability of the European Court, but it's also important to be able to bring cases closer to home. So now we can ask local courts and tribunals tribunals to hear human rights cases. Really interestingly, if you look at the figures since the Human Rights Act was passed and kind of came into being, in the kind of, it was passed in 1998, but kind of became operational in 2000. And after a couple of years of operation, if you look at the statistics at the Council of Europe and the European Court of Human Rights, you can see a real drop in the number of cases involving the UK. And that's because lots of cases can be resolved now in the domestic courts, whereas previously we had no way to bring those cases in UK courts. So again, it's kind of an interesting way to look at some of the arguments around, is there too much influence by the European Court of Human Rights, when actually sometimes it's only about 4 cases a year, and actually it's the UK judges that are making those decisions. So we're kind of bringing those decisions back home. And it's also important to kind of talk about the Human Rights Act in terms of Section 2, and what our courts will try and do is what the Human Rights Act says is to take into account how cases have been decided by the European Court of Human Rights. And so that's quite reflective of the way that we have this principle of legal certainty in the UK, but particularly the English legal system. It's this idea that we kind of have a bit of certainty of knowing sort of what the law is. And again, that's become quite controversial because sometimes that is talked about as kind of giving over too much power to the European Court of Human Rights, for example, but actually we're talking about the UK kind of institutions making those decisions. And if we went back to pre-Human Rights Act, we couldn't make any of those decisions here at home, and they had to go to the European Court of Human Rights. So again, kind of some interesting unpicking of some of the arguments around that. So what does this all kind of mean? For us and the work we do, we talk about how the legal duties in the Human Rights Act help us to speak up, because we all have human rights that should be respected and protected. They can help us talk to services about whether they're meeting our legal duties. They can help us work with services so that we can kind of reduce the need to go to court. And I think this is kind of the area that BRHR kind of works in that we see lots of kind of big political discussion about human rights, which is often focused on a real iceberg tip of legal cases, but there's very little discussion of how the Human Rights Act is actually working for people in their day-to-day lives. And it's really important that we don't kind of lose that aspect of it. And there are 16 rights set out in the Human Rights Act. So this is all 16 of them on your screen. Often we ask people to guess how many there are, and sometimes people get very carried away into the kind of hundreds, but it is only 16 rights. And these are the ones that we have. And I think, am I handing over to you now, Annie?
There's a little bit about the absolute and non-absolute.
Oh, absolute, non-absolute. I'll do that bit then, and then I'll hand over to you for the actual rights. Perfect, great. One thing to also say about actually these rights, these 16 rights, is that they are, you won't see things like my right to healthcare, for example, in here. And that's because the idea is that these are sort of broad principles that apply in all of our interactions kind of with government power. So lots of these things will be relevant when we're interacting with healthcare, for example, like our right to life, or our right not to be harmed or treated in an inhuman or degrading way. So sometimes you might not necessarily see the thing that you're thinking of sort of there, but actually it is very much covered by the rights. And then the absolute, non-absolute is also really important, because I think there's often a perception that somebody says, well, that's my human rights, and that's the kind of end of the conversation, when really it's the start of the conversation. And this idea that we have some rights which are considered absolute, so they can never be restricted. That's really important, particularly when we're campaigning, because if we think one of our absolute rights, for example, the right to not be tortured or treated in an inhumane or degrading way, is at risk, that's a really clear red line that that's an action that shouldn't be happening, and a proposal that shouldn't be happening. So it gives us kind of, added power to that argument that, in our own human rights law and in international human rights law, this is a red line and shouldn't be happening. But also kind of, it's important to say that most of the rights in our Human Rights Act are actually non-absolute, so they can be restricted in certain circumstances, but that restriction needs to follow this 3-stage test. So it should be lawful, so there should be a law permitting it. It should be legitimate, which is set out in the rights themselves, and normally the ones that come to mind are or that are most relevant are to protect the person or the wider community or national security. They're the ones that get used most often, but they are actually written in the texts of the rights themselves. So it's useful to kind of go back to those. And it should be proportionate. And I think from a campaigning perspective, that's really helpful, because it means that you're not saying there can never be any restriction of this particular right. You're just saying that actually what's being proposed here is not proportionate, and that there are other ways to achieve the legitimate aim that is kind of concern in this situation. Of course, you might not think that there is a legitimate aim, and that's another argument that you might want to use as well. But I think it's quite important when you're thinking about kind of actually making the argument about rights to, if you're talking about a non-absolute one, that acknowledgement that yes, this can be restricted, but it's what is being restricted, the manner of the restriction, the reason for the restriction, and to actually open up that conversation and that dialogue, and to get some traction that way. So I think I'm going to stop talking at that point, and Annie's going to look at a couple of the rights that are in our Human Rights Act, which we think are probably some of the key ones that are at risk in terms of the kind of draft laws, the bills that are being proposed at the moment.